It's River to River from IPR News. I'm Ben Kiefer. Well, it was a term for the history books at the U.S. Supreme Court. The justices affirmed birthright citizenship. They cleared the way for the Trump administration to end temporary protected status. We know that by TPS for Haitians and Syrians. Overturned a 90-year-old precedent that protected independent federal agencies from presidential control, while making a surprising exception for the Federal Reserve. They also upheld state bans on transgender athletes in women's sports and rejected a Republican challenge to how states count mail-in ballots. That's our focus today with Drake University scholars Sally Frank and Miguel Schor. They're here in our Des Moines studio to unpack it all, including what these rulings mean, especially for us Iowans. Sally Frank is professor of law at Drake University. Miguel Schor, professor of law, associate director of Drake University's Constitutional Law Center, and class of 1977 distinguished scholar. Miguel and Sally, welcome to our program. Thank you for coming in.
Thank you.
Thank you. Glad to be here.
We're going to be pivoting back and forth between the two of you. You've sort of divided up these cases to help us dig into them. So some will be on Sally's shoulders, some will be on Miguel's shoulders, and we'll see what we get here. Let's start with, I guess, the big one, birthright citizenship, Trump v. Barbara. It was last week, June 30th, that the Supreme Court struck down President Trump's executive order attempting to end birthright citizenship for children born to parents who are undocumented or here temporarily. It was a 6-3 decision written by the Chief Justice, Roberts. The court held that the 14th Amendment's Citizen Clause guarantees citizenship to virtually everyone born in the U.S. On our soil, rejecting the administration's argument that such children aren't subject to something called subject to jurisdiction of the United States. The case was named for Barbara, a Honduran asylum seeker who, with her child, became the lead plaintiff in a nationwide class action suit. Sally, start us off. What was the president's executive order actually trying to do, and how did Barbara end up as the face of the case against it?
Well, what he was trying to do was eliminate a whole category of people from becoming citizens. It's part of his efforts to change the nature of who is an American, change the color of who is an American, and basically get rid of that time when we expect that whites will be a minority. And so this was a key aspect of it because people born in the United States under birthright citizenship are citizens. Many states filed suit against it, and they were joined together. So Barbara was just the name of was the person who gave birth and whose child would otherwise not be a citizen. And what's actually remarkable about the case was, while it was 5 to 6 to 3, in actuality, it was 5-3-1. Kavanaugh said that there was no need to look at the Constitution. It was just statutory, and therefore, if Congress changed the statute, that people could be denied citizenship. So the real shock was there's an over 100-year-old precedent that said people born in the United States are citizens, except for a very narrow exception. And Trump actually got 3 or 4 votes in his favor.
Take us into that specific constitutional question that you referred to. This is an 1898 case, Wong Kim Ark. Tell us a little bit more about that and how, I guess, the administration leaned on that case. Tell us about that case.
Well, the people before the court were Chinese. At the time, we had a Chinese exclusionary statute that prevented Chinese people from coming, and there was an attempt to bar his children from citizenship. And the court went back to the very statute and said that the very constitutional provision, which was based on many years of common law brought into the United States from England. So it was a many centuries old principle that if you're born in the United States, you're a U.S. citizen. The exception generally says unless you're subject to the jurisdiction of the courts, that exception would mostly be people who have diplomatic immunity, because if they commit a crime, they're not subject to the laws and to the court's jurisdiction. Undocumented immigrants, if they commit a crime, they can be imprisoned. They're subject to the court's jurisdiction. Temporary residents, the same thing. The only people who are not are people with sovereign immunity. If a head of state comes to the United States and commits a crime, they have sovereign immunity. Or, as we said, ambassadors and other people in a position have diplomatic immunity.
Mm-hmm. You mentioned Justice Kavanaugh was an outlier here. He agreed with the executive order was unlawful, but for a different reason, a federal statute, not the Constitution itself. So what is the practical difference there? Does that open the door for Congress, perhaps?
Well, if his position had gotten more votes, it would. But there were still 5 justices who joined Roberts' opinion that said the Constitution provides this. So, but if Kavanaugh had held sway, then Congress could just amend the law and say people who are born to undocumented immigrants aren't citizens. It would have and either way, it would have wreaked havoc in hospitals, in vital records departments, because how are they going to figure out which person is giving birth in their hospital? That whether they have status or not, whether they're green cards or they're visitors or they're undocumented, the headache would have been enormous.
Yeah. That's what I want to ask about, because we have, according to the data that I have, roughly 200,000 children born each year in our country to immigrant parents. They were the intended targets of this order. So that's the chaos that may have happened had this gone the other way. And do justices also consider such, ramifications when they're making this, in addition to whether the Constitution allows this or not?
I don't think they do in writing particularly, but obviously it has an impact on their rulings. And some of the immigrants who give birth are green card holders or permanent residents of the United States, so they would not be affected by Trump's order. So even within the scope of the immigrants, the hospital would have to figure out which category of immigrant this was.
Iowa has a growing immigrant population, we know, meatpacking, agricultural communities. That would have been something to end the birthright citizenship for families of these immigrants, like towns like Denison, Storm Lake, or West Liberty, right, Sally?
Yes, and the implications would have been fairly enormous in terms of, as I say, figuring out who's a citizen and giving birth certificates to people, and the risk of deportation of people who have never known any place but the United States because they were born here. But it would have eliminated a large group of citizens who are not white.
Mm-hmm. This ruling announced last week. In the meantime, there's been some reaction to this ruling, as there have been to other rulings. We'll talk about that later in the hour. But just yesterday, President Trump announced on Truth Social that he will formally petition the Supreme Court to rehear Trump v. Barbara. So how realistic is this? Is there a mechanism to do that, given that the court hasn't granted a rehearing like this in decades, right?
Well, in theory, it can be done, but in practice, there's no reason for the court to rehear it unless there were a shift on who the members of the court were. And maybe it may be that Alito might retire, but that would not have an ideological shift in the court. There's no reason for them to spend their time to hear it again.
So even if this hearing bid fails, as expected, is there a practical effect of the president publicly attacking a decided ruling, which is certainly not a norm we have from modern presidents? He used the words absolutely insane decision about this. Does that matter, for instance, for how lower courts or agencies implement it in the meantime? Does it have any effect when a president comes out so strongly with these words?
Not really. I mean, it. Other presidents have criticized other rulings. For Trump, it's like anything that goes against him, he highly criticizes. So the practical effect is somewhat minor, but as the justices think about other issues, they may be choosing which ones they want to get his ire and which ones they'll just capitulate. So it could have a subtle impact.
Mm-hmm. Does this change anything? Because we have certainly listeners, immigrant families listening. Does this change anything about the timeline or the certainty for immigrant families listening who are counting on the June 30th ruling being final?
It is final. And if it had gone the other way, it would have had huge ramifications. But having kept the law as it is just really status quo.
Okay. We'll be back after a short break to talk more with our Drake University scholars about the key recent Supreme Court decisions that affect our lives here in Iowa and, of course, across the country. Sally Frank, professor of law at Drake University. Miguel Schor, also professor of law, also associate director of the Drake University Constitutional Law Center. And when we come back, we'll talk about temporary protected status. This is Mullen v. Doe. In another case, this happened just 5 days before the birthright citizenship ruling. The court went the other direction in this one on immigration. We'll talk about it when we return. It's River to River from IPR News. Back with more River to River from IPR News. I'm Ben Kiefer. Joining us today, two Drake University scholars to pick apart, to discuss the key Supreme Court decisions in recent days. Sally Frank and Miguel Schor. And we just concluded talking about the birthright citizenship ruling. Before we move on to another immigration-related ruling, Miguel Schor, tell us a little bit about your thoughts on the case that Sally walked us through.
So I want to pick up where the question that you asked, about the language that President Trump used. So it's not that the words he used are unusual, right? But presidents have attacked Supreme Court opinions. And I think the case to keep in mind is President Lincoln, in his first inaugural address, ripped into the worst case ever decided by the Supreme Court. That's Dred Scott. And his point was that we can't leave the final word to the meaning of the Constitution to the court. And so there is a path forward. If you don't like that decision, and that is right, you can seek to amend the Constitution. And I think that's important to keep in mind. There is an avenue for people who want a different result, and it's utilizing Article 5 of the Constitution.
Mm-hmm. Do you think, Miguel, that's likely, given our political landscape right now?
It's remarkably difficult, right, to amend the Constitution, and that's why I thought Kavanaugh's concurrence was so interesting, because the conservatives on the court always talk about originalism, right, the meaning of the text, but really he was talking about the problems that we have today are different from what we did back then, and so he wanted to give Congress the power to actually change that. But that's not the system that we have, right? I mean, the meaning of that language in the Citizenship Clause of the 14th Amendment is very clear, right? It is the British rule. And that has been understood since the founding of the American Republic. And so the only path forward would be to formally amend the Constitution.
Right. And you mentioned Dred Scott. That comes up a lot in legal conversations here. Remind us, Dred Scott,
sure.
You said the worst decision by our U.S. Supreme Court.
Yeah.
In brief, what was that decision? It involved a slave.
Yeah, right. It was a decision that said that that African Americans could not be citizens of the United States, right? Full stop. And so it it was easily the worst decision ever made by the Supreme Court. And as Chief Justice Roberts pointed out in Trump versus Barbara, he called it an odious decision. It had sought to overrule the common law rule that if you're born here, you are a citizen. And it was overturned the way you overturn Supreme Court decisions by this citizenship clause of the 14th Amendment, right? Mm-hmm. And so it was designed to overturn Dred Scott. So everyone born here would be a citizen as long as they were subject to the jurisdiction that was subject only to the exceptions that, if you were foreign diplomats or the children of an invading army. But other than that, you were a U.S. citizen.
Mm-hmm. Let me turn back to Sally Frank. Let's turn to temporary protected status, another immigration-related case decided last week. Just 5 days before the citizenship ruling, I should say, the court went the other direction on immigration, clearing the way for the Trump administration to end temporary protected status for roughly 350,000 Haitians, 6,000 Syrians. It was a 6-3 decision on June the 25th, written by Justice Alito. The court ruled that the federal TPS, it goes by that acronym, the temporary protected status, that statute largely bars courts from reviewing the Department of Homeland Security's decision to terminate the designations, including claims that the decision was racially motivated. Sally, walk us through this and tell us, what did the court say about whether federal courts can review a TPS termination at all, even one alleged to be discriminatory?
Well, they basically said that they can't, that not only was the final decision not subject to review, as Congress had put in the statute, but even if the Secretary of Homeland Security violated the statute in how she determined that temporary protected status should end, that was beyond the reach of the courts as well. And so her arbitrariness in deciding it, or the extent to which she was ratifying Trump's racist statements, were irrelevant, and that equal protection also did not bring it there. Justice Thomas went so far as to say there was no equal protection against the federal government, that the federal government was free to discriminate. They also tried to kind of whitewash, it's really whitewashing, Trump's statements by giving a slight summary, because if anybody read those statements, it would be obvious that the decision was based on racism. Yeah,
we had the former DHS Secretary, Kristi Noem, called Haitians leeches. That was one of the evidence of a racial motive, but that didn't carry the day, Sally.
No, it didn't. So this is where maybe they were only willing to take Trump's wrath so far, and that the citizenship case, knew they were going to rule against him, and so they gave him this immigration case. These are people who have been living legally in the United States and working and being productive members of our community, some for 15 years, and overnight they lose their status and can be deported as undocumented immigrants. This, it's going to cause major harm to health care, to agriculture, and many other areas.
Right, and let's zero in on the impact here on Iowa. Haitian immigrants, really a core pillar of the workforce in several major Iowa meatpacking hubs. Ottumwa, for instance, the JBS pork processing plant, that's the town's primary employer, has a substantial Haitian workforce. Go up to Waterloo, the massive Tyson Foods pork plant there relies heavily on international workforce, Haitians, but also Bosnian, Congolese. Haitian workers have established a footprint area in that. So we have across the Midwest meatpacking plants, companies actively recruiting Haitian workers. And as you mentioned, Sally, they've been here in some cases many years to handle these. These are high-speed production lines. And so weigh in here. Miguel, did you have a view on this, this going the other way?
Well, how about this? I agree with Sally that the dissent had it right, that this was animated by race. But you can actually make a defense for what the majority did, and I think it's important to bring it out, which is that when it comes to equal protection, that was really the main claim here. There's sort of two tests. One is more deferential, and that came from actually a case called Trump versus Hawaii, where the court said, look, as long as there's a legitimate reason for why the government is doing something, it doesn't matter if there are also some illegitimate reasons. And that applies to excluding people from the United States. The court said it wouldn't apply that standard. It would apply the normal equal protection standard, and all that requires is that race is a motivating factor. But the court took into account all the circumstances, and that included immigration. And so what I worry about after this case is that all the sort of normal rules of the Constitution will become a lot more deferential as long as the government says this is about immigration. I think that's a problem, and it shouldn't have done that. But that is what the majority did in Mullins versus Doe.
Justice Kagan had a dissent here. Part of the dissent warned of, quote, devastating and indeed life-threatening harm to people who built their lives here in good faith. And I mentioned, that the Haitian communities, other immigrant communities here in Iowa. Sally, what does that look like in practical terms for these families now? Can we know that?
Well, they are within 30 days subject to deportation. So a very abrupt change in their lives, and deportation to a country that, nobody can seriously say that Haiti is a safe place to return to. And so the process that they refuse to look at doesn't hold. Noam did not really ask the State Department in any serious way whether Haiti was safe, and that's supposed to be the standard. Just look at the travel advisories the State Department puts out, and it tells Americans not to go there, that it's very, very dangerous, and yet we're going to be sending back thousands of people to that very dangerous situation.
And I understand authorization documents for Haitian and Syrian TPS holders expires tomorrow, July 10th. So that's a deadline that's impending right now.
Right. And the government, of course, has their addresses and all the information about them. And they could, in 2 days, just round up those thousands of Haitians and put them in deportation proceedings.
Yeah, I wonder if Haiti and Syria is the end of this or the first domino. For instance, which other countries' TPS holders should be watched closely right now?
Afghanistan. All those people that we let in because they helped our soldiers could be thrown out. And there are many other countries. Essentially, anybody from a third world country is going to be subject to this. Ukraine may be different because Ukrainians are white generally, but we'd have to see on that.
Yeah. If you just joined us, we're reviewing some of the key cases that just were decided by the U.S. Supreme Court in the term that just concluded. Miguel, before we move on, did you want to have anything to wrap up on those cases that had to do with immigration before we move on?
No, I think, what I worry about in all of these cases is the kind of cruelty that we're doing this. There are procedures in place that would have taken care of that, but the court refused to enforce those. Yeah.
We have 5 or 6 minutes before we take a break. Let's jump into Trump v. Slaughter. This has to do with independent agencies, and the court overturned on June 29th a 90-year-old precedent ruling that 6-3, again, that the president can fire FTC commissioners at will without the for-cause protection that Congress had written into the law. The case grew out of Trump's 2025 firing of Democratic FTC Commissioner Rebecca Slaughter. Chief Justice Roberts wrote that officials who exercise the president's executive power must be removable by him. Tell us about Rebecca Slaughter, and what did the president actually say when he fired her, Miguel?
Well, yeah, so this is the kind of case that matters a lot for people who sort of teach in this area, and it may not necessarily resonate quite as much with the public, but it really should. And what matters is this. The presidency is not just a person, it is also an office. And the most important people working in that office are called principal officers, right? They are put there by the president, they're confirmed by the Senate, and the Constitution has rules for appointment. It says nothing. It says nothing. It is silent about removal. Right. And there have been sort of two views on what that power is. One is the view that you saw in that case. It's called the unitary executive theory, and it's the idea that all executive power belongs to the president, and that includes the power to hire, to fire, and to command. The other one was in the case that you just talked about, which was Humphrey's executor, and that was the case that said, well, Congress created these agencies, so sometimes there's a reason why you might want to have some independence. And that's a lot of agencies, right? Since the late 19th century, there were over 50 agencies. Some of them actually date from the early days of the American Republic. But the majority said no. The meaning to execute is very clear. They said this was a decision also made by the first Congress, right? They relied on a case called Myers. And the dissent pointed out, I think quite rightly, one, that Congress created these agencies, so therefore it should be able to place limits. But also it said, look, this gives more power than the monarch had, right? Since Parliament put limits on that as well. And what this turns on, right, and to me these are the big sort of the top-line issues. One, among conservatives, there's a real dislike of the administrative state. Everything that was done sort of, by FDR and afterwards, and this is a piece of that. And there are sort of two views about that. The unitary executive theory, right? It's all about that separation of powers is all about efficiency. You want to give all that power to the president so that things actually get done. Those who dislike it, who like Humphrey's executor, think that the whole point of the Constitution, separation of powers, is friction, right? And that what they worry about is that this gives the president really a dangerous, right, amount of power. And this is where we are. By the way, I think that it's worth paying attention to Gorsuch's concurrence, who was obviously with the majority, but he pointed out that he's one who clearly dislikes administrative agencies, and he said, we have given far too much power. Congress has given too much power using these administrative agencies, and he would find ways to cut that back after we gave all this power to the president, because he recognized that the sheer amount of authority that the president will now be able to wield is just massive, right? And that's a problem.
Yeah, in her dissent, Justice Sotomayor, going back to what you just mentioned, that she said this is a power unknown even to the English crown, against which the founders revolted. I wonder, Miguel, do you think that's hyperbole or a fair reading of what's changed here?
No, I think that is. I think that is fair. There's a line I always like. There's a justice called Louis Brandeis who was actually in the majority, a very good justice in Humphrey's executor, and he said many years afterwards, he said, imagine what would happen, he said, if Huey Long, and Huey Long was the governor of Louisiana, and the closest thing, I grew up in Louisiana, by the way, the closest thing you've ever seen to a dictator in this country. And imagine if someone like him were to become president and Humphrey's executive was not the law. And so that's the problem, right? This is nothing animated the framers more than the problem of unlimited authority, right? The Declaration of Independence is all about, the abuses of the monarch, right? The Constitution is all about placing limits on power. The unitary executive gives power to the president and places no limits on that power. And what the dissent said is that the president's job was to take care that the laws be faithfully executed. Now with this power, the president can actually tell his agents to break the law, and they will go ahead and do it, right? And I think that's a fair concern.
Yeah, and Miguel, after the break, we want to talk about the exception, the Federal Reserve exception. But to wind up here, legal analysts already mapping this ruling's fallout across the government. We have many agencies, FCC, CPSC, all named as vulnerable. So the ruling didn't just decide this one case. Should Iowans expect faster swings in things like labor rules, product safety enforcement, every time the White House changes hands now? Has it?
Yes.
Yes.
Oh, yeah. And in fact, that was a point that Hamilton made. So Hamilton and the Federalists said that actually Congress could limit the removal of principal officers. But his point was, unless you're able to do that, then every election of a president will be sort of like a mini revolution. It will be a massive transformation, and that is absolutely true. That will happen going forward. The stakes of each election will get even higher, and people will fight even harder over who becomes president. That is the future that we will see.
Yeah. Sally, you agree with Miguel's assessment there?
I do, and what I worry about are the next cases. The FBI agents who are suing because they were fired for investigating January 6th. The U.S. attorneys who are suing because they were fired. So the civil service. Will this decision affect the everyday federal workers?
Mm-hmm. Okay, we have to take another break. We're so glad to have with us two esteemed Drake University law scholars, Sally Frank and Miguel Schor, as we have them walk us through the latest key rulings by the U.S. Supreme Court and implications for our country and especially for us here in Iowa. When we come back, we'll talk about a decision that came out the same day as Slaughter in a separate 5-4 ruling. The court reaching an opposite conclusion for the Federal Reserve. We'll have Miguel talk us through that one when we return. It's River to River from IPR News. Back with more River to River from IPR News. I'm Ben Kiefer with Miguel Schor and Sally Frank, two Drake University law scholars, walking us through the implications and the reasoning behind the latest key U.S. Supreme Court rulings, the last ones of this term. Miguel and Sally, we'll have to pick up the pace a little bit here. We've got a few cases to get through in the final 20 minutes. Let's move through these.
Sure.
It's fascinating to hear your analysis of these and how they will change our society and perhaps our lives. Now, the same day as the Slaughter ruling, there was a separate 5-4 ruling reaching the opposite conclusion, rejecting the administration's attempt to immediately remove federal Fed Governor Lisa Cook, the first governor ever targeted for removal in the central bank's 111-year history over a disputed mortgage fraud allegation. Miguel, walk us through why the president wanted to remove this governor, Cook, why she says actually the real motive, in her view, was her refusal to cut interest rates.
Sure. Well, how about this? You asked earlier whether the Supreme Court ever cares about the consequences of the decision. Mm-hmm. That was this case, right?
Okay.
They were clearly worried about what would happen to the economy if they didn't say the Fed was independent. And so this is the one place where a restriction on removal will be upheld when it comes to the Federal Reserve. And the question is, why did the court do that, right? And it said, remember, this is a court that believes in sort of history and tradition, and said, well, in the early American Republic, both the first and the second bank, which were somewhat similar to the Federal Reserve, had that kind of independence. Then they gave a reason, which is that unless the central bank has independence, nobody will trust the central bank. They quoted Alexander Hamilton on that. Mm-hmm. And we had all of these financial panics until the creation of the Federal Reserve, right? And so for those reasons, right, they said there was independence. The dissent didn't really quite get into that too much, other than Justice Thomas. He really said, no, she's not. Yes, she can be fired. Why? Because the unitary executive theory that we applied in Slaughter should apply here as well. There are no exceptions. And by the way, and I think actually he was right on this, the Federal Reserve exercised much more power than the first and second Bank of the United States. But I think what won the day was Kavanaugh and his concurrence, who said, we have to decide this issue. We have to decide in favor of the Fed because the political and economic uncertainty is just too big. So now we have an exception. But here's the thing. If you have an exception, why you need independence, why is this the only one? Why aren't there other ones as well?
Yeah. Iowans feel Fed decisions directly as, Americans across the country do. Mortgage rates, farm loan rates, ag credit. Miguel, why does market confidence in an independent, apolitical Fed matter in a place like Iowa? Why was that so important? Talk a little more about that.
Well, I think the Chief Justice laid it out in his history, and he had some fun with this, by the way, in that he's pointed out, look, the first bank and the second bank would set monetary policy and that helped prevent finances. The person who got rid of it, and this is where he had some fun with it, was a president by the name of Andrew Jackson. And Andrew Jackson is often the president who's most closely identified as being similar to Donald Trump. And Jackson just didn't want an independent bank, and so he got rid of it. And then the nation went after one financial panic after another financial panic after another financial panic, and they finally decided they had to have an independent central bank. That was the creation of the Federal Reserve in 1913, and that has made a massive difference, right, in terms of the American economy ever since. And so there, I think that the practical consequences were so staggering that the court upheld the independence. And they pointed out, sometimes you want agencies where decisions are made by experts and not by politicians, right? Mm-hmm. And that would be the Fed.
Yeah. And the president already said in his reaction to this, of course he didn't like it, he plans to try again with, quote, proper process. What would a do-over attempt actually look like? Could it succeed this time, Miguel?
Well, the court punted on a lot of the issues. So yes, there's a for-cause removal, but they gave some idea of what that cause might be, right? It has to be something that shows real unfitness for office and not just a pretext for the political reasons. And they didn't really spell out what the process is other than a notice and it ought to be heard. So there's a lot of things to be litigated down the road. And so he can try to follow the proper procedures now to get rid of her.
Mm-hmm. Let's move to a key decision by our high court on transgender athletes in sports. To you on this, Sally. On June 30th, the court ruled 6-3 that states may bar transgender girls and women from competing on female school sports teams. The consolidated cases, one was from Idaho, one from West Virginia, tested whether Title IX or the Equal Protection Clause protects transgender athletes' access to sex-segregated teams. It's notable here that Iowa passed its own such law back in 2022. What did the court actually decide about Title IX's definition of sex, Sally, and how does that differ from the court's equal protection ruling here?
Well, the court was basically unanimous on the Title IX issue, saying that Title IX is the law that protects women, protects everybody, but generally bars sex discrimination in higher education and in others throughout the education system unless you're an all-male school or an all-female school. That was passed in 1972. In 1974, there was an amendment to it that really emphasized that included sports. And so once they say you can have separate male and female sports, then a challenge to how that's being done is not going to pass. And that was unanimous. The real crux of the issue in the fight was about equal protection. And were they violating BPJ and HECOX's equal protection rights by barring them from being on women's teams? It is interesting to say, of course, that these laws do not bar transgender men from being on men's teams. They only bar transgender women. And BPJ was an especially compelling case because she knew from a very, very young age that she identified as female and that she had puberty blockers, which, last year's decision allows states to bar children from having puberty blockers, but she had puberty blockers, and so she never underwent endogenous male puberty. And then she also was having estrogen. So, and she never felt so good before being on these sports teams. The psychological impact was huge. She was very much a loner, but then in middle school, when they challenged the statute and she was permitted to participate, she opened up, she made friends, she felt part of the community. And all of that's kind of ignored by the Supreme Court. And one of the things that's interesting is that Alito would not call her a transgender girl or woman. He instead kept saying biological males who see themselves as female. And Thomas wouldn't even go that far. He basically said men who have gender dysphoria.
Right. And to be clear, Sally, that defies what we have as current science about the spectrum of gender as we understand it?
That's correct. There is a question about how puberty blockers and estrogen affect sort of innate athletic ability. And the dissenters said equal protection shouldn't have been decided without a full trial so that evidence could come in and be considered and weighed because it's still fairly new and we're not sure. But they've decided it without even having that trial on it.
Mm-hmm. This will be continued because we need to move on. But as this is a last note looking forward, I read that a leading conservative legal group has told blue states, you're next. We have 27 states with existing bans, including Iowa. So we'll think about what that could. It seems Iowa's state law, the state ban, insulated from future legal challenge by this decision. But we have Iowa's neighbor, Minnesota, which has the opposite policy, something to watch there. I want to move on to mail-in ballots, Watson v. Republican National Committee. This is a 5-4 reading to you on this, Miguel. The court siding against the Republican National Committee, upholding Mississippi's law allowing mail-in ballots postmarked by Election Day to be counted if they arrive up to 5 days later. What was the RNC's core argument here, Miguel, about an 1845 Election Day statute? And why didn't that persuade the majority?
Well, I think what did a lot of work here is the structure of the Constitution. And by the way, this is where Hamilton had another moment because he played an important role in this case. He wrote in the Federalist that the way we structure elections, we do not put the rule in the Constitution. We give that job to the states, subject to a potential override by the federal government. And the reason for that is just impossible to come up with a rule that's going to fit all the various states. And so I think what played a big role here were the federalism concerns that 30 states allow late ballots. And so the court said, look, this is the way, the majority, I should say, said this is the way our system works, which is that states get to administer federal elections unless, of course, Congress were to write a law to the contrary. And all that the election law means is that the actual ballot must be cast by the election day, but you can count late ballots. And for the dissent, they looked at historical practices and said, look, when these laws were written, everybody voted in person. And so the votes, of course, were cast and received on the day of the election, and no state thought it could do it differently. And so that, therefore, there should be a different result, that there should be no late ballots. And they also talked about fraud. But I do want to point out that Justice Alito, in his dissent, relied on a hypothetical about fraud because there's remarkably little evidence that this actually is a problem.
Mm-hmm. Miguel, Iowa already, for several years, requires mail ballots to be received, not just postmarked by 8 p.m. on Election Day. Does this ruling change anything for us as Iowa voters, or is this really a story about other states?
This is a story about how important it is to have a decentralized system of elections. It makes it really difficult for anyone to take control of that, and it gives the states a lot of power over that. And so if Iowa wants to do it differently than other states, in that case, for example, Alaska filed a friend of the brief case saying that we can't do our election by Election Day, all of it, counting the ballots, because we have people living out there in the middle of nowhere. Right, and so this is an important case about federalism.
Of course, reaction to this as well, the president renewing his push for the Save America Act again in his July 4th speech, calling for photo ID, proof of citizenship, and a near total end to mail voting. Notably, though, even some Republicans in Congress reportedly pushing back on parts of the bill, even within the president's own party, some resistance to the SAVE Act as written, something there to watch here. And to you, Sally, on this, let's broaden our scope a little bit as we end here. The mail-in ballot ruling didn't happen in isolation. It capped a term of steady erosion of voting rights protections. Let's end with your comment about those, because this was only the latest, wasn't it?
Well, the court has definitely had a mission, basically from the Federalist Society, to overturn the Voting Rights Act. They did the first huge step many years ago when they stopped independent review for certain jurisdictions, and suddenly all these restrictions on voting came in. And then this year they said you can't protect minority districts. And so what happened immediately, Louisiana postponed its election and rewrote its district lines. So the great effort of the Voting Rights Act, which was to enforce the 15th Amendment, is being restricted and basically written out of existence and we're kind of entering a new end of Reconstruction in some ways.
Mm-hmm. Miguel, the Voting Rights Act, do you agree with that assessment by Sally?
Well, my take's a little different on this. I think the real problem is gerrymandering, right? And that's a case that was much older than the cases that Sally was talking about. That's a case called Rucho versus Common Cause. And that said that if politicians gerrymander, that is non-justiciable. That means the court will not review it. That is a huge problem for the United States of America. The reason why the court said that was because the framers engaged in gerrymandering, so therefore it should be legal today. There's some real problems with that. They didn't have computers, right? The early gerrymanders were absolutely awful. They tried to gerrymander James Madison out of his seat. It didn't happen. Good for us, because he was in the first Congress and wrote the Bill of Rights. But that is no longer the case. And so the New York Times at the last election cycle showed that over 90%, well over 90% of all state and federal elections are not competitive. They're decided by more than 5 points, and that means all that matters is the primary. And so we get a very polarized Congress, and that's a problem. There is no country in the world, no long-standing democracy in the world that divides power as much as the United States does. Right? There are 22 nations that have been democratic since 1950. All of them have less divisions than we do, right? And that means to get anything done, people have to be willing to bargain. They have to be willing to compromise. That is the beauty of our system. And gerrymandering makes that impossible. And that's on the Supreme Court. They could have stopped it.
Mm-hmm. We have 1 minute left. Retirement watch. We always have to include a question about that. NPR briefly on June 30th and erroneously reported that Justice Alito had retired. The story was retracted within minutes. Given Senator Grassley that he chairs the committee that would vet any nominee, what should we watch for if a seat does open up before the November elections? Quickly, please.
They're going to appoint somebody as quickly as possible because the Senate is in Republican hands, and they can't be sure that an ultra-right-wing person would be affirmed if the Senate ends up in Democratic hands.
Mm-hmm. Miguel, final word to you on this?
We are remarkably polarized. We fight. We're going to fight every election. We're going to fight everyone who's on the Supreme Court. It does no nation no good, but that's where we are.
Mm-hmm. And with Justice Barrett, though, we do have some surprises. She's receiving a lot of heat for her vote in that last case we talked about, isn't she, Miguel?
Yeah, well, these are, yes. I mean, you never know in advance how a judge is going or a justice is going to vote, and that's important. And so I think that's important to keep in mind. That said, it's just we're far too polarized in terms of who gets on the Supreme Court, yep. and that's just a real problem, right? The divisions are very deep.
Miguel Schor and Sally Frank, you've made this incredibly accessible to us without the legal background that you have. Thank you so much for coming into our Des Moines studio.
Thank you for having us.
Thank you very much.
Today's program produced by Caitlin Troutman, technical support from Nev Kelly, Tony Sarabia, and John Pemble. I'm Ben Kiefer. Thanks for joining us.